times voted to return him to the bench, I believe he's well qualified to serve our nation in the federal courts as a district judge. Justice Gerrard's nomination deserves our support, and I again urge my colleagues to support him today. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Vermont.
Mr. President, I want to compliment the Senator from Nebraska for his comments. I totally agree with him, and I would ask consent to insert in the record my statement on judicial nominations and my strong support of John Gerrard of Nebraska, so read.
Without objection.
And, Mr. President, I ask to proceed as in morning business to speak about an important effort to help the American economic recovery and preserve American jobs.
Without objection.
We have rogue websites, Mr. President, that are primarily based overseas. They're stealing American property. They're harming American consumers. They're hurting the American economic recovery. And they're costing American jobs. You know, stealing and counterfeiting are wrong, and they're harmful. It's happening every day right under our noses. And we lose jobs, and we Americans lose money as a result. The Institute for Policy Innovation estimates that copyright infringement alone costs more than $50 billion a year. And the sale of counterfeits online is estimated to be several times that. The AFL-CIO estimates that hundreds of thousands of jobs are lost to these forms of theft. Hundreds of thousands of jobs that we could have right here in America if it wasn't for this kind of thievery. And it's not just an economic or jobs problem for Americans. It's a consumer safety issue. According to a study released earlier this year, a couple dozen websites selling counterfeit prescription drugs had more than 140,000 visits a day. Counterfeit medication, brake lining, and other products threaten America's safety. Excuse me.
Clerk will call the roll.
Mr. Akaka.
President.
Senator from Vermont.
I ask consent to call the quorum be dispensed with.
Without objection.
Mr. President, I ask that the call of the quorum not disrupt the record of my speech.
Without objection.
When you talk about counterfeit medication, you talk about the thievery, you talk about the hundreds of thousands of American jobs lost. They're serious concerns. And they're the kind of concerns I've had in mind over the last several years. So I've worked with senators on both sides of the aisle to help resolve these problems. Now, I admire and I respect the marvelous advances of technology, particularly those represented by the Internet. I'm on the Internet early in the morning and probably again late at night as I catch up with messages, the latest news, and so forth. I promoted its impact around the world, especially in countries where it was the only way the people of that country could have a free voice. I fought from the time the Internet was invented to keep it free and open, so it's become the incredible force it is today. I promoted its potential for access in rural areas, for distance learning, for increasing points of view, for allowing all voices to be heard, as a means for small startups and firms in Vermont and elsewhere to market quality products. Now, this is not a newfound interest or passing fancy. I started and chaired a Judiciary Committee panel 2 decades ago on technology and the law as a founder of the bipartisan, bicameral Congressional Internet Caucus. Now, yesterday, the Washington Post got it right in its editorial entitled Freedom on the Internet. said a free and viable Internet is essential to nurturing and sustaining the kinds of revolutionary innovations that have touched on every aspect of modern life. But freedom and lawlessness are not synonymous. The Constitution does not protect the right to steal, and that's true whether in a bricks-and-mortar store or online. And last week, a Wall Street Journal editorial spoke in a similar fashion. Now, 2 years ago, I introduced a bipartisan effort to target the worst of the foreign rogue websites that profited from piracy and stealing and counterfeiting, while also ensuring that we protect the Internet. And I've been working since that time to do just that. In 2010, the bipartisan bill I introduced was reported unanimously by the Senate Judiciary Committee. I took views of all concerned. I reached out to the administration. We incorporated revised definitions suggested by other senators like Senator Wyden. We held additional hearings to which we invited Google and Yahoo. We redrafted the legislative measure. We reintroduced it as the Preventing Real Online Threats to Economic Creativity and Theft of Intellectual Property Act, the Protect IP Act. Senator Grassley joined me as the original co-sponsor. I continue to work with Republicans and Democrats who showed interest. Measure was reported unanimously from the Judiciary Committee. In May of 2011, 40 senators from both Democrats and Republicans across the political spectrum co-sponsored. Now, it's rare that editorial boards with divergent viewpoints such as the Wall Street Journal and the Washington Post agree. Here they do. They've already noted the problem of foreign rogue sites, websites engaging in piracy, theft, and counterfeiting. Is one time when they do agree. Today, Mr. President, I asked the copies of the editorials I've referenced being included with at the end of my remarks.
Without objection.
This is an issue that unites the United States Chamber of Commerce and the AFL-CIO, the National Association of Manufacturers, and the Teamsters, the cable industry and the broadcast industry. Now, these are all groups that are usually taking different positions on different things. They're united on this. By targeting the worst of the worst and protecting the integrity of the Internet, we get a broad coalition of support for the Protect IP Act. And law enforcement groups, of course, more than 400 companies, associations, unions have come together to support it. Now, last year, forming similar coalitions, we were able to reform our patent laws to unleash American innovation and also to boost our economy. We have to look for the same threat here, because there's a serious threat to our economic recovery posed by Internet piracy. Now, I have remained flexible on this. I've listened to people both for and against the legislation, made changes in it along the lines suggested by others, such as Senator Wyden. I took seriously the concerns about the domain name system provisions. So we fix that in the manager's amendment. So I regret that we're not going to go forward with it this week. I regret that so much misinformation has stopped. I thank Majority Leader Reid for trying to schedule a debate on this serious economic threat. And I understand that the Republican leader recently objected, and a number of senators who had co-sponsored and long supported the effort jumped ship. He was faced with a difficult decision. And I understand as leader, he did what he had to do. But I hope after a delay, we can come back together and work on this. I've talked to people who have been strong supporters like the distinguished senator from Arizona, Senator Kyle. I certainly continue to work with him. He's been an absolute leader in this area, and I applaud the work he's done. This is an act that's been years in the making. It's been waiting Senate action since last May. Now today, the rogue foreign websites that are based in Russia, they're stealing Americans' property, are delighted to continue the operation. Counterfeiting sweatshops in China are the beneficiaries of this delay. Some of the sweatshops that are employing children, basically in slave labor, they turn out these counterfeit products that are on the websites. They've got to be happy we've lost a tool to go after them. And having listened to some of the misinformation I've seen recently on the same internet I'm trying to protect, I would point out that our bill would only affect websites that have been judged by a federal court to have no significant use other than engaging in theft, whether it's through stolen content or they're selling a counterfeit. It's narrowly targeted, the worst of the worst. Websites that have some infringing content in their sites but have uses other than profiting from infringement are not covered by the legislation. I saw one website, Wikipedia, say they've got to go dark. They censored themselves to protest what they called censorship. Our law never would have touched a website like Wikipedia. What it does do is go after organized crime in Russia and China and elsewhere. I worry about the flash of interest that surrounded this bill last week. Those who were forgotten were the millions of individual artists, creators, companies in Vermont and every other state who work hard every day only to find their works available online for free without their consent. Those who lost are the factory workers whose wages are cut or jobs are lost. When low-quality counterfeit goods are sold in place of the real thing they work so diligently to produce. There are men and women of our National Guard and military who put their lives on the line for all of us every day. But yet if they acquired a counterfeit part, it can literally be a matter of life or death. Or seniors who are struggling to pay for their medications. See one of these websites where they can find them for a little bit less. But the medication is going to protect them from a heart attack. Instead, they have a counterfeit. An organized crime group is making money, but they're the ones who die. So at the end of the day, the debate boils down to a simple question. Should Americans and American companies profit from what they produce and be able to provide American jobs, or do we want to continue to let thieves operating overseas steal that property and then sell it to unsuspecting American consumers? And I would hope that in the coming days the Senate will be able to focus on stopping theft that's undercutting our economic recovery. I remain committed to confronting that problem. I appreciate the efforts of people like Senator Kyle, Senator Alexander, and others who want to continue to work in a thoughtful manner with all interested parties to find an effective solution to eliminate online theft by foreign rogue websites. And I thank those senators who called me in Vermont and back here this past weekend when I got back to Washington to offer their help, senators on both sides of the aisle. It means a lot. Now, I know the senior senator from Nebraska is waiting to speak about the judicial nominee from his state. I'll say what I've said to him privately, because I know this is his last year in the Senate. I've always enjoyed working with him. He's worked hard. He's represented the people of his state well. He's been very honest in his dealings with me. He's been diligent with respect to judicial nominations for a vacancy in Nebraska. He's tirelessly pressed to fill vacancies there to ensure the cases before the federal court in Nebraska were not needlessly delayed. He did that to protect everybody in Nebraska, Republicans or Democrats alike, to make sure the courts were open for them. I'm sorry that the confirmation of Justice Gerrard, one he so strongly supported, has been needlessly delayed for more than 3 months. But I'd say the people of Nebraska are fortunate, are very, very fortunate to have the senior senator from Nebraska, my friend Ben Nelson, who's been there fighting for him, fought for people of Nebraska every day from the day he took the oath of office, and maybe his last year here. But based on past performance, I think it's safe to say he'll fight for Nebraska right up until the moment that adjournment bell sounds. I yield the floor.
Mr. President.
Senator from Nebraska.
Mr. President, I thank my colleague, the esteemed chair, for such kind remarks. I wish they were universally believed by all, but it's a kind of introduction that my father would have enjoyed, but my mother would have believed, and I appreciate so very much kind comments. The Nebraska Supreme Court temporarily stayed the execution of one prisoner, a Carrie Dean Moore, because a full evidentiary record was before it in another case, immediately pending case, State versus Mata, which was referred to by my friend and colleague from Alabama, Senator Sessions. That case challenged the constitutionality of electrocution as a method of execution. It did not challenge, it did not deal, and it was not associated with whether or not to have a death penalty, was not challenging the death penalty, but the methodology of the death penalty. The court had to determine whether a prisoner should be executed before that question was soon answered. The temporary stay was issued, and the other case decided as a matter of state constitutional law. The court, by a vote of 6-1, determined that electrocution as a method, and I emphasize a method of execution, violated prohibitions against cruel and unusual punishment, which is the purview of the court to make a determination when there's a question dealing with the Constitution. The court was clear that the death penalty remained valid in Nebraska, no writ of certiorari taken. The Nebraska legislature changed the method of execution to lethal injection, and the sentences of Moore, Mata, and others will be carried out accordingly. As a matter of fact, the court has set a date of execution for a prisoner to be executed on March the 6th. This same court set dates of execution while I was governor on 3 occasions, and they were carried out. Judge Gerrard was a member of the court at that time and has no objections to the execution. It's the methodology that the court dealt with. So it's important to recognize that in Moore, the issue was not whether the death penalty itself was constitutional. It was whether a particular means of execution was constitutional. Those are completely different questions. Senator Sessions claims that Judge Gerrard stayed the defense execution in light of a, quote, changing legal landscape, end of quote. However, it's not uncommon for a court, when presented with different cases involving related issues, to withhold ruling on any one case until all of the related issues are resolved. Therefore, the Moore order reflects a pragmatic decision to wait until both cases could be resolved. Now, I agree with Senator Sessions that this is about the duty of a judge to be faithful to the law and to serve under the law. However, I strongly disagree with Senator Sessions' characterization of Judge Gerrard as an activist judge. Judge Gerrard has written 450 opinions in his 15-plus years on the Nebraska Supreme Court. The U.S. Supreme Court concluded in a previous case that the Nebraska Supreme Court, both the U.S. Supreme Court and the Nebraska Supreme Court have repeatedly held that the death penalty is not cruel and unusual, and Judge Gerrard would have no difficulty following that binding precedent. As a matter of fact, he has. He has no personal beliefs that would prevent him from enforcing the death penalty. In fact, he's authored several opinions and voted to affirm the convictions and death sentences of defendants who've actually been sentenced to death, as I've said. Judge Gerrard believes the death penalty is an acceptable form of punishment. He understands the significant difference between a judge on a court of last resort interpreting state court constitutional law and a federal district judge who follows U.S. Supreme Court precedents. So I'd like to reiterate for the record that Judge Gerrard is held in the highest regard by both the bench and the bar in Nebraska. He's earned an AV Martindale-Hubbell rating from his colleagues, and the American Bar Association has deemed him unanimously well qualified to serve as a U.S. District Court. I thank my colleague, Senator Johans from Nebraska, for his support and his comments, I think, which were also very supportive, clearly supportive of Judge Gerrard and the decisions and clearly that he is not an activist judge. I thank the President and the body, and I yield the floor.
Clerk will call the roll.
Calling of the quorum be suspended.
Without objection.
Just over a month ago, December 17th, the Senate entered into a unanimous consent agreement to consider the nomination of John M. Gerrard of Nebraska to be District Judge for Nebraska. We are proceeding with this nomination because I'm going to support it, despite the President's action on recess appointments. During the last session, we acted responsibly in considering the President's nominees. Even the Majority Leader acknowledged this. He stated, quote, "We've done a good job on nominations the last couple of months. Actually, in the last 3 months, we have accomplished quite a bit," end of quote of Senator Reid. I will have more to say about the recess appointments. But with regard to this nomination, I hope my colleagues understand that even though we are proceeding under regular order today, it is only because this unanimous consent agreement was locked in before the President demonstrated his monarchy mentality by making those recess appointments. I'm not going to hold this nominee accountable for the outrageous actions of the President. However, as this is a matter of concern to my Republican colleagues, as it should be to every one of the 100 senators, we must consider how we will respond to the President and how we will restore constitutional balance. Since the adoption of the unanimous consent agreement governing this nomination, President Obama has upset the nomination process. Article 2, Section 2 of the Constitution provides that only 2 ways in which the President may appoint certain officers. First, it provides that the President nominates and by and with the advice and consent of the Senate appoint various officers. Second, it permits the President to make temporary appointments when a vacancy in one of those offices happens when the Senate is in recess. On January 4, the President made 4 appointments. they were purportedly based on the Recess Appointments Clause. He took this action even though the Senate was not in recess. This action is of utmost seriousness to all Americans. These appointments were blatantly unconstitutional. They were not made with the advice and consent of the Senate, and they were not made during the recess of the Senate. Between the end of December and today, the Senate has been holding sessions every 3 days. It did so precisely to prevent the President from making recess appointments. It followed the same procedure as it had during the term of President Bush. Honoring the Constitution and the desire of the Senate, President Bush declined to make recess appointments during these periods. But President Obama chose to make recess appointments despite the existence of these Senate sessions. In addition to being unconstitutional, these so-called recessed appointments break long-standing tradition. They represented an attempted presidential power grab against this constitutionally consecrated body, the Senate. A president has not attempted to make a recess appointment when Congress has not been in recess for more than 3 decades or for more than 3 days in many, many decades. In fact, for decades, the Senate has been in recess at least 10 days before the President has invoked this power. Other parts of the Constitution beyond Article 2, Section 2, show that these purported appointments are invalid. Article 1, Section 5 provides, quote, each House may determine the rules of its proceedings, on and on, end of quote. In December and January, we provided that we would be in session every 3 days. The Senate was open and provided the opportunity to conduct business. That business included passing legislation and confirming nominations. In fact, the Senate did pass legislation which the President signed. According to the Constitution, each House, not the President, determines whether that House is in session. The Senate said we were in session. The President recognized that fact by signing legislation passed during one of those sessions. Article 1, Section 5 also states, quote, or partial quote, neither House shall, during the session of Congress, without the consent of the other, adjourn for more than 3 days, end of quote. The other body did not consent to our recess for more than 3 days. No concurrent resolution authorizing an adjournment was passed by both chambers. Under the Constitution, we could not recess for more than 3 days. We did not do so. The President's erroneous belief that he can determine whether the Senate was in session would place us in the position of acting unconstitutionally. If the President is right, we recess for more than 3 days without the consent of the other body. And, of course, that would be a ridiculous position to take. By claiming that we were in recess, the President effectively dares us to say that we failed to comply with our oath to adhere to the Constitution. Yet, it is the President who made appointments without the advice and consent of the Senate while the Senate was in session. It is the President who violated the Constitution. Of course, the President does not admit that he violated the Constitution, for he has obtained a legal opinion from the Office of Legal Counsel at his own Department of Justice. That opinion reached the incredible conclusion that the President could make these appointments notwithstanding our December and January sessions. That opinion is entirely unconvincing. For instance, to reach this conclusion that the Senate was not available as a practical matter to give advice and consent, it relies, would you believe it,
on such unpersuasive material as statements from individual senators. However, the text of the Constitution is very clear. It allows no room for the Department to interpret it in any so-called, quote-unquote, practical way that departs from the terms of the Constitution. The Justice Department also misapplied a Judiciary Committee report from the year 1905 on the subject of recess appointments. That report said that a Senate recess occurs when, quote, the Senate is not sitting in regular or extraordinary session as a branch of Congress, or in extraordinary session for the discharge of executive functions, when its members owe no duty of attendance, when its chamber is empty, when, because of its absence, it cannot receive communication from the President or participate as a body in making appointments, end quote. Obviously, that report does not support the Department of Justice. During these days, the Senate was, in fact, sitting in session. It could discharge executive functions. The chamber was not empty. It could receive communications. It could participate as a body in making appointments. In fact, it sat in regular session and passed legislation. There is nothing in this 1905 report from the Judiciary Committee of the Senate that justifies the President substituting his judgment for the Senate's regarding whether the Senate is in session. In any event, a Senate Judiciary Committee report from 1905 does not govern the United States Senate in 2012, 107 years later. The Senate, as constituted today, decides its rules and proceedings. The Department is on shaky legal ground when it claims that, quote, whether the House has consented to the Senate's adjournment of more than 3 days does not determine the Senate's practical availability during a period of pro forma sessions, and thus does not determine the existence of a recess under the Recess Appointments Clause, end of quote, from the Department's opinion. There is no basis, none, for treating the same pro forma sessions differently for the purposes of the two clauses. The Department simply cannot have it both ways, yet it tries to. And the Justice Department's opinions contains other equally preposterous arguments. For instance, the opinion claims that the administration's prior statement to the Supreme Court through former Solicitor General Kagan that recess appointments can be made only if the Senate is in recess for more than 3 days are somehow distinguishable from its current opinion, or that the pocket veto cases do not apply, or even if they did, the quote-unquote fundamental rights of individuals that the courts described in those cases include the right of the President to make recess appointments. Now, we all remember that there was a time when the President believed that they could take legal action only when the law gave them the power to do so. They obtained advice from the Justice Department on the question of whether there was legal authority to justify the action they wished to take. But Theodore Roosevelt started to change the ways that presidents viewed power. He believed that the President could do anything so long as the Constitution did not explicitly preclude him from acting. When he used that theory to create wildlife refuges against a rapidly expanding industrial base, there appeared to be no objection. But without objection, what happened? A dangerous precedent was set when he claimed that he could make recess appointments during a quote-unquote constructive recess of the Senate rejected this view in that 1905 report. When a president thinks that he can do anything the Constitution does not expressly prohibit, the danger arises that his advisors will feel pressure to say that the Constitution does not stand in the way. At that point, a president is no longer a constitutional figure with limited powers as our constitutional founders intended. Quite to the contrary. The president looks more and more like a king that the Constitution was designed to replace. This Office of Legal Counsel opinion reflects the changes that have occurred in the relationship between the Justice Department and the President on the question of presidential power. Formerly, the Justice Department gave legal advice to the President based upon objective reading of text and judicial opinions. It was not an offshoot of the White House counsel's office. This more objective view of the limits of presidential power also provided a level of protection for individual liberty, the principle at the core of our constitutional separation of powers. The President might refuse to accept the advice. He might choose to fire the officer who gave him advice with which he disagreed. He could seek to appoint a new officer who would provide advice he preferred. But you know what? If he did those things, he risks paying a political price for doing so. An official who thought that loyalty to the Constitution exceeded his loyalty to the President could refuse to comply at great personal risk. That is what Elliot Richardson did during the Saturday night massacre of the Watergate era. During the Reagan administration, the Office of Legal Counsel issued opinions that concluded that the President lacked the power to undertake certain acts to implement some of his preferred policies. The President did not undertake those unilateral actions. President Obama originally submitted a nominee for the Office of Legal Counsel that was wholly objectionable. The Senate had good reason to believe that she would not interpret the law without regard to ideology. We refused to confirm her. The President ultimately withdrew her nomination and nominated instead Virginia Seitz. We asked important questions at her confirmation hearing and through questions for the record. Ms. Seitz responded that OLC should adhere to its prior decisions in accordance to the doctrine of stare decisis. And she stated that if the administration contemplated taking action that she believed was unconstitutional, she would not stand idly by. Relying on those assurances, the Senate confirmed Ms. Seitz. Ms. Seitz is the author of this wholly erroneous opinion that takes an unprecedented view of recess appointments clause. And I suppose it is literally true that Ms. Seitz did not stand idly by when the administration took unconstitutional action. Rather, she actively became a lackey for the administration. She wrote a poorly reasoned opinion that placed loyalty to the President over loyalty to the rule of law. That opinion and her total deviation from the statement she made during her confirmation process shows extreme disrespect for the institution of the Senate, but more importantly, for the constitutional separation of powers. I gave the President and Ms. Seitz the benefit of the doubt in voting to confirm her nomination. However, after reading this misguided and very dangerous legal opinion, I'm sorry the Senate confirmed her. It's likely to be the last confirmation that she'll ever experience. Mr. President, the Constitution outlines various powers that are divided among the different branches of our federal government. Some of these powers are vested in only one branch, such as granting pardons and conducting impeachment proceedings. Other powers are shared, such as passing and signing or vetoing bills. The appointment power is a shared power between the President and the Congress. When one party turns a shared power into a unilateral power, the fabric of the Constitution is itself violated. And, of course, a response is called for. In Federalist 51, Madison wrote that the separation of powers is more than a philosophical construct. He wrote that, quote, the separate and distinct exercises of different powers of the Constitution is essential to the preservation of liberty, end of quote. The framers of the Constitution wrote a document that originally contained no Bill of Rights, as we know. They ended up being the first 10 amendments to the Constitution. They believed at that time that liberty would best be protected by preventing government from harming liberty in the first place. That was the reason for the separation of powers. And they designed a working separation of powers through what we learn in school as checks and balances to ensure a limited government that protects individual rights. Madison wrote, quote, ambition must be made to counteract ambition. The interest of man must be connected with the constitutional rights of the place. That is what the framers intended in a case such as this. When the Constitution, when the President unconstitutionally usurped the power of the Senate's ambition would check the President. In this way, the Constitution is preserved. The power of the government is limited, and the liberties of the people are protected. But the framers did not anticipate the modern presidency. It took Justice Jackson's famous concurrence in the Youngstown case to address presidential powers in today's world. I was a college student at that particular time. Didn't mean much to me at the time, but it means a lot today what Justice Jackson said in that court case. When the Judiciary Committee held its confirmation hearings on President Bush's Supreme Court nominations, my friends on the other side of the aisle posed many questions about the Jackson concurrence. That opinion shed light on these so-called recess appointments. For instance, President Obama argued in a nationally televised rally that his actions were justified because, quote, every day that Richard, meaning Richard Cordray, waited to be confirmed was another day when millions of Americans were left unprotected, and I refused to take no for an answer, end of quote. Justice Jackson anticipated these hyperbolic statements. He wrote, quote, this is in the Youngstown case, quote, the tendency is strong to emphasize the transient results upon policy and lose sight of enduring consequences upon the balanced power structure of our republic, end of quote. President Obama has definitely let transient policy goals overtake the Constitution. His argument is that the end justifies the means. Pretty Machiavellian, isn't it? His argument is that he can say no to the Constitution, or in essence, that the Constitution does not apply to him. But the Constitution demands that the means justifies the end, and that adherence to established procedure is the best protection for liberty. A monarch or a king could say no to the Constitution, but under our Constitution, the President may not. It is the Constitution and not the President that refuses to take no for an answer. Justice Jackson was also aware that the modern president's action, quote, overshadow any other, and that almost alone he fills the public eye and ear. By virtue of his influence on public opinion, he wrote, the president, quote, exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness. Some people believe that President Obama challenged the Senate for partisan purposes. But Justice Jackson understood that the true partisan dynamic that is now playing out. He recognized that the president's powers are political as well as legal. Many presidential powers derive from his position as head of the political party, Jackson wrote, and I quote Jackson. Party loyalties and interests, sometimes more binding than law, extend his effective control into the branches of government other than his own, and he often may win as a political leader what he cannot command under the Constitution, end of quote. And so Jackson concluded this way, something that we ought to take to heart. Quote, only Congress itself can prevent powers from slipping through its fingers. Mr. President, that's end of quote. Outside these walls, in the reception room, are portraits of great presidents, or great senators of the past, in the room right out here. The original portraits were selected by a committee that was headed by Senator John F. Kennedy. They include Webster, Clay, Calhoun, La Follette, and Taft. Now, these senators were partisans, but they were selected because the role they played in maintaining the unique institution that is our Senate, meaning the People's Senate, in our constitutional system. In particular, they protected the Senate and the country from the excessive claims of presidential power that were made by chief executives of their time. Where are such members today? Where is a member of the President's party today who is like the most recent Senate institutionalist that Robert C. Byrd was? He defended the powers of the Senate when presidents overreached, even presidents of his own party. Where are the members who recognize that our sessions every 3 days rightly prevented President Bush from making recess appointments, but who stand idly by as President Obama makes recess appointments without a recess? In other words, what's different between the years 2007 and 2008, when we had a Republican president and Democrat Senate, when we recognized what recess appointments were and the president recognized the same thing, but today, 2011 and 12, things seem to be somewhat different. I remind my colleagues of my experience as chairman or ranking member of the Finance Committee. I refused to process nominees to positions that passed through that committee to whom President Bush gave recess appointments. That is how I used the authority that I had to protect the rights of the Senate. I do not believe that we should let the powers vested in elected representatives of the American people slip through our fingers because we place partisan interests above the Constitution. I have shown how the framers understood that supposedly expedient departures from the Constitution risked individual liberty. The constitutional text in this situation is very clear. It must be upheld. We must take appropriate action to see that it is done, nor should we wait for the courts. Although the NLRB appointments are already the subject of litigation, we should take action ourselves rather than rely upon others. The stakes are too high. On the other hand, even the OLC opinion recognizes at most the litigation risk to the president. For more than 200 years, presidents have made very expansive claims to power under the Recess Appointment Clause. The President and the Senate have worked out differences to form a working government. Now, this administration seeks to upend these precedents and that working relationship. It may well find, as the Bush administration did, that when overbroad claims of presidential power find their way to the courts, that not only does the president lose, but that the expansive argument of the presidential power that had long been a part of the public discourse can no longer be made. Although I believe that this ironic result will ultimately occur here as well, the Senate must defend its constitutional roles on its own as intended by the framers of the Constitution that we all swore an oath to uphold. I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka. Is there objection? Without objection? Is there a sufficient second? There appears to be. All time has expired. Clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt, Mr. Bozeman, Mrs. Boxer, Mr. Brown of Massachusetts, Mr. Brown of Ohio, Mr. Burr, Ms. Cantwell, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Chambliss, Mr. Coates, Mr. Coburn, Mr. Cochran, Ms. Collins, Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. DeMint. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mr. Franklin. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kerry. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenborough. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson of Nebraska. Nelson of Florida. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada. Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Sanders. Mr. Schumer. Mr. Sessions. Mrs. Shaheen. Mr. Shelby. Ms. Snow. Ms. Stabenow. Mr. Tester. Mr. Thune. Mr. Toomey. Mr. Udall of Colorado. Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Mr. Webb. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Akaka, Aya, Bingaman, Brown of Massachusetts, Burr, Cantwell, Cardin, Carper, Conrad, Coons, Crapo, Enzi, Feinstein, Gillibrand, Grassley, Heller, Inouye, Johans, Johnson of South Dakota, Kerry, Cole, Leahy, Levin, Lugar, McCain, Nelson of Nebraska, Portman, Rockefeller, Warner, Webb, Whitehouse. Senators voting in the negative: DeMint, Inhofe, Isaacson, Sessions, Shelby, Vitter. Mr. Brown of Ohio, Mr. Brown of Ohio, aye. Mr. Wicker, no. Mr. Blumenthal, aye. Mrs. Boxer, aye. Mr. Coburn, aye. Ms. Klobuchar, aye. Mr. Lee, no. Mr. Reed of Rhode Island, aye. Mr. Wyden, aye. Mr. Franken, aye. Mr. Roberts, aye. Mr. Casey, aye. Mr. Moran, aye. Mr. Rubio, no. Mr. Bennett, aye. Mr. Pryor, aye. Ms. Collins, aye. Mr. Paul, no. Ms. Landrieu, aye. Mr. Manchin, aye. Mr. Nelson of Florida, aye. Mr. Coburn, no. Mr. Cochran, aye. Mr. Menendez. Mr. Menendez. Aye. Mrs. Shaheen. Mrs. Shaheen. Aye. Ms. Snow. Ms. Snow. Aye. Of Wisconsin. Mr. Johnson of Wisconsin. No. Ms. Markowski. Ms. Markowski. Aye. Mr. Bozeman. Mr. Bozeman. No. Mr. Merkley. Mr. Merkley. Aye. Mr. Risch. Mr. Risch. No. Udall of Colorado. Mr. Udall of Colorado, aye. Mrs. McCaskill. Mrs. McCaskill, aye. Mr. Kyle. Mr. Kyle, aye. Mr. Toomey. Mr. Toomey, aye. Mr. Toomey. Mr. Toomey, no. Mr. Corker. Mr. Corker, aye. Mr. Coates. Mr. Coates, aye. Mr. McConnell. Mr. McConnell, aye. Mr. Harkin. Mr. Harkin, aye. Mr. Udall of New Mexico. Mr. Udall of New Mexico, aye. Mr. Tester, aye. Mr. Begich, aye. Mrs. Murray, aye. Mr. Alexander, aye. Mr. Baucus, aye. Mrs. Hutchison, aye. Mr. Thune, aye. Mr. Barrasso, aye. Mr. Schumer, aye. Mr. Reed of Nevada, aye. Mr. Durbin, aye. Ms. Stabenow.